If you've just been arrested for domestic violence under Penal Code Section 273.5a, corporal injury to a spouse or cohabitant, aka felony domestic violence, you might be thinking, can I really go to prison over a bruise? Or it wasn't even that bad. How did this turn into a felony? Well, you're not alone in asking those questions, and the answers may surprise you. In this video, I'll break down exactly what this charge means, what the worst case scenario could look like, and what steps you can take right now to protect yourself. Stick around until the end, because understanding the charge is the first step in fighting it. My name is Veronica. I'm a domestic violence criminal defense attorney, and I help people throughout the entire state of California put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you how to represent yourself at a restraining order hearing and win. So if that is something that you are dealing with in addition to a criminal case, make sure to get your free first class down below. Okay, so let's jump right in. Penal Code Section 273.5a is California's felony domestic violence law. It covers situations where someone allegedly caused a physical injury to a current or former spouse, cohabitant, that means you live together, dating partner, fiance, or the parent of their child. And here's what most people don't realize. Even something like a bruise, a red mark, or a minor scratch can trigger this charge. What the prosecution must prove. Now let's talk about what the prosecution actually has to prove in court to convict you. They have to prove three things, and all three must be true. Number one, that you willfully inflicted the injury. Willfully just means that it was done on purpose, that it wasn't an accident. Number two, that the person injured was somebody in a qualifying relationship with you. So a spouse, cohabitant, fiance, dating partner, or the parent of your child. Number three, that your actions caused a traumatic condition, a physical injury, or a wound, even a minor one. The prosecution has to prove all three of those things beyond a reasonable doubt in order to convict you at trial. Possible penalties. Next, let's go over the penalties if someone is convicted. PC 273.5a is what we call a wobbler, meaning it can be charged as a misdemeanor or as a felony. That decision depends on the facts of the case and on your criminal record or lack thereof. Now, if it's charged as a misdemeanor, the possible sentence is up to 1 year in county jail. If it's charged as a felony, the punishment can be up to 4 years in state prison for a first offense. If you have that domestic violence prior from the past 7 years, a felony conviction could mean up to 5 years in state prison. But beyond jail or prison time, a conviction under 273.5 usually comes with other serious consequences. You may be ordered to attend a 52-week batterer's intervention program. You could be placed on probation. There could be a protective order for up to 10 years issued to keep you from seeing or contacting the alleged victim. You will lose your gun rights, both under federal and state law if you're convicted. You might have to pay restitution or contribute to a victim fund. Now, restitution means that the alleged victim claims that as a result of your actions, you cost them money. It could be medical bills, but it could also be housing expenses, therapy, missed time from work, and it can add up to quite a bit. You could also be fined up to $6,000 for a first offense or up to $10,000 if you have a prior conviction within the last 7 years. And in some cases, many cases, it can affect your professional license or your immigration status. Now, keep in mind though, these are the maximum penalties. These are the worst case scenarios that I promised you at the beginning of this video. When you get arrested though for PC 273.5a, there are a whole range of possible outcomes depending on what action you take. Now, every case is different and there are no guarantees, but I recently had a client facing exactly this charge, PC section 273.5a, with a prior conviction within the past 7 years. And because of that prior conviction, he was facing up to 5 years in state prison. But we acted early, we presented the right information, and reached out to the prosecution before charges were filed. And in the end, the case was dropped. Now, in another version of reality, he might have waited, done nothing, and ended up serving time in state prison. But he was smart, he acted early, and he avoided all of that completely. Defenses to PC 273.5a. Now let's talk about legal defenses to corporal injury to a spouse or cohabitant charges. There are three main defenses that apply here. The first is self-defense or defense of others. If you used reasonable force to protect yourself or someone else from immediate harm, then that can be a legal defense, and it's a complete defense, meaning that you could be found not guilty because of this. Now, let's get into an example. Let's say that Mel and Dell they're a couple and they're arguing. Dell lunges at Mel with a kitchen utensil. Mel shoves Dell back in self-defense, and Dell falls and gets a black eye. That's not domestic violence. That's justified force to protect yourself from being hurt. But keep in mind that there are nuances to this. Just because the other person attacked you first does not mean that your case counts as self-defense. Number 2, accident or lack of willful intent. Remember, the law requires that you acted intentionally, aka willfully. If it was an accident, then it does not qualify under PC 273.5a. For example, Tay and Ray are arguing in their house when Ray trips over the dog and bumps into Tay, who falls and hits her head. Tay ends up with a bump, but it was truly an accident. No intent, no crime. Tay calls the police, though, and Ray is arrested for PC 273.5a. Now it's up to Ray and his attorney to show that this was an accident, and that even though he and Tay were in an argument, he never meant to bump into her. And in a case like this, details are going to be important. Where were they in the house? Maybe we need a diagram. Where was the dog? How big is the dog? We might need some photos of the dog here. Number 3, false accusation. Sadly, false accusations do happen, especially in domestic violence cases where there are often messy breakups or custody battles. For example, Jan and Stan are splitting up. Jan wants full custody of their daughter, and after a heated argument, Stan leaves to cool off. A few hours later, Jan calls the police and says that Stan hit her earlier in the night. She shows the police a bruise on her arm, but Stan has no idea where that bruise came from. He just knows that he didn't cause it. Stan gets arrested. Now he's facing charges under PC 273.5a, and Jan files for custody the next day. It's up to Stan and his attorney to show that Jan's accusations are false. They need to break down Jan's statements, show that Jan had a motive to lie, and if she's been inconsistent, to point that out. If she already had the bruise or if she got it from someplace else, to show evidence of that, and if it comes down to it, to ruthlessly cross-examine her on the witness stand to show that she is lying. Now, other defenses might apply too, like insufficient evidence or proving that the relationship doesn't fall under the statute. Maybe you were just casually dating. And remember, just because you are charged does not mean that you are guilty in the eyes of the law. There are legal standards that the prosecution must meet, and a lawyer who's fighting for you showing the prosecution that they can't prove their case, or at least they're going to have problems doing so, or that one of those defenses apply, or even that you are someone who deserves a second chance can be the difference between a conviction and a complete dismissal. Winning one of these cases comes down to a detail-oriented approach. An experienced attorney can and should be looking into the facts, gathering evidence like medical records or witness statements, and presenting the strongest defense possible. Sometimes charges can be reduced or dismissed entirely, especially if you act early and have an attorney contact the prosecution before your first court date. I hope you found this video helpful. If you do have a criminal case in California, feel free to book a consultation. You can find a link down below. You can also find my phone number there. If you're dealing with a restraining order, remember, get your free first class and defeat the DVRO via the link down below. And if you did find it helpful, please don't forget to like, subscribe, ring the bell, and if you have a question or comment, leave it in the comments.